everybody. Welcome to IP Chatter. My name is Janelle Lacey. I am an intellectual property attorney here in Atlanta. So today we're talking about patents, which is my absolute favorite area of IP law. I love to see people's brains just working in ways that we haven't seen before. I love to see new advancements in technology and science. My background is in science, so I love chemistry, I love medicine. I spent 10 years in the medical field. I love this area. It makes me really excited, so I'm really excited to talk to you today. Now, anybody can be an inventor. You could be scientists, engineers. Those are usually the main ones that we think about, but you could be stay-at-home mom, dad. You could be a 9-to-5 person. You could be a student. I mean, anybody could come up with something that can be an invention. So let's talk about what a patent is. Now, a patent covers an invention. Most patent terms are for 20 years, unless you have a design patent, which is going to be for 15 years. So it allows you exclusive use to manufacture, to sell, to license, to bring into the United States if you're coming from a different country, to enforce infringement rights. It gives you that exclusive use to your invention. Now, how do you get that patent? It needs to be something that is novel, something that's new, something that is useful, and it has to be non-obvious. Now that's a big one too, because you can't claim an invention that is obvious to a prior invention. So what that means is that somebody who is skilled in the art of whatever area that your invention's in, so say it's in the chemical area or it's in the electrical engineering area, if somebody looks at a previously patented invention and they look at your invention, and that person who's skilled in the art can easily go from that previous invention to your invention, they call that obvious. Something where it didn't take a lot of effort or a lot of thought to get from number one invention here to your claimed invention here. So what that means is that you have to have something that is truly unique, something that is a true improvement over any previous invention that's already been patented. So patent law is very cumbersome. It's very technical. There's certain skills that are needed to be in patent law. And so there's a lot that really goes into it. Today I'm going to try to simplify it, and I just want to give you some points, some tips of what you should be looking for and kind of what that process is going to look like. So first and foremost, you have to have a lot of patience when it comes to filing a patent, because it could take maybe 3 to 5 years in order to have your patent granted. So it'll take maybe 1-2 years before the patent examiner even looks at your patent application. It just depends. A patent office is backed up. So it just depends on how backed up they are in your field of invention. And I can imagine that probably the technical field, the electrical engineering field, or mechanical is probably pretty backed up, because there's so much technology that's coming out every day here. Maybe a design application might not take as long. Not sure about that. But nevertheless, you want to make sure that you have some patience. Just know that if you file your application in May of 2020, by December of 2020, don't expect to have your patent. Don't even expect to have the examiner have looked at your application, because they're probably not even close to looking at your application there. So that's just an aside there. So there's different types of patents. You can get a utility patent, which is the broadest area of patents. So pretty much most of the patents that you hear are going to fall into this category. Then you have a design patent. A design patent is just what it sounds like. It's a new, novel, ornamental design. So Nike has designs on their shoes. You can have designs on a baby's crib or a television, or it's just a broad spectrum. Patents cover just a vast area. So there's no just this, and this will fit into the category. It just really depends on how you are claiming that invention and in which category you're trying to put it in. And then lastly, there are plant patents. So yes, you can patent a plant, but you can't go outside and get a sunflower and say, hey, I discovered this sunflower, let me patent it. That doesn't work. Again, it has to be newly discovered, and you have to be able to asexually produce that plant in order to get an application. Now, I don't know how many patent applications or plant patent applications that are out there, but some of you guys who have a green thumb or who are into agriculture and that kind of thing, that's your area. All right, so now the next thing is, what can you not patent? So what I said earlier is that it's such a broad area. There's so much that you can patent, but there are some things where the patent office is going to say, no, we're not patenting that. They kind of put it into the categories of natural phenomenon, laws of nature, and abstract ideas. And so within those three categories, again, it's very broad. There's different things that fall into it. There are also exceptions to those three categories if it's significantly different or adding more to those categories that are usually non-patentable, then you can get a patent there. So when you submit your patent application to the patent examiner, it goes through a lot of scrutiny. There's a lot of boxes, if you will, that need to be checked, and there's a lot of hoops that you need to jump over, and these are just some of those that you need to be aware of. All right, so you can't patent a human. If you somehow figure out how to clone a human, guess what? You're not going to be able to patent that. So again, things that are naturally occurring in the earth, DNA, you cannot patent that. Different things like that. That butterfly that's outside, you can't just put it in a little mason jar and try to patent it. All right, so now that you kind of have an idea of what you can patent and what you can't patent, let's talk about ideas. Now, ideas are not patentable. So what that means is, if I say, you know what, I have a great idea. I want to make a time machine so that we can jump from May of 2020 to January of 2021. Who's on board? I'm sure there's plenty of you that would be on board for that right now. Well, guess what? I have no idea how to do that. When you submit your patent application to the patent officer, the examiner needs to be able to look at your description and be able to reproduce whatever your invention is, or somebody who is skilled in that particular art needs to be able to make your invention. So it's not enough to just have a great idea. You have to show the patent office how that idea works. So if I have a medication that is a cure for coronavirus, for the COVID-19, I need to show them what that formula is and how that chemical formula is going to interact and how it's going to work. Now, you don't necessarily have to have it already made or already built out, but you just need to be able to describe it in such sufficiency so that the patent examiner can understand how it works. All right, so I know I said a mouthful there, but that's also really important. It's not enough just to have the idea. You have to know how to make it work. All right, so we know we can't clone humans. We know it can't be obvious to another invention. We have to show how it works. I know that sounds simple, but it's a lot of stuff that really goes into each of these steps. So if you're thinking about patenting something, if you have an idea, or if you've already put it into practice, or you already have a model or an idea of how it works, you definitely want to talk to your patent attorney or patent practitioner so that you can get an idea of what the next steps are. And again, remember, be patient. It is a long process. So another thing I want to talk about is there's different patent applications. So timing is absolutely of the essence when it comes to patent law. If you are not the first person to file your patent application, you will not get your patent, and there's very few exceptions to that. So in March of 2013, the Patent Office went from a first to invent to a first to file. And so it used to be, if you invented first and somebody else got to the patent office before you, but you could prove that you invented that patent first, then you were able to get your patent. granted to you. Now that's not the case. Even if you came up with it first, 5 of you could come up with that same thing, but whoever gets to the patent office first and whoever gets that filing date first is the person who is going to get that patent. So it's very important that once you are ready, once you have that concept, it's a working concept, that you go ahead and get filed before somebody else does. Another thing that's very important is that there's a lot of statutory bans to what will stop you from getting a patent. One of the things that you want to be careful is not to be telling people about your invention, because if it's been known to the public or it's been in use of the public, say you come up with a new scooter and everybody in your town is using this scooter, you've been selling it, you've been marketing it online. If it's been more than a year before your filing date, that will bar you from getting a patent. So just be very careful. There are, again, of course, some exceptions to that. If it's something in the chemical or in the sciences and you're doing some experimentation and that kind of thing, that's a little bit different. But if it's been out into the public, that's a big deal. And you only have a year for it to be out in the public before that becomes a bar for you to get that patent. So please keep that in mind. Keep it to yourself. You could talk to your patent attorney or your patent practitioner, but you don't want a whole bunch of people out there using, and definitely do not start selling your invention more than a year before you get on file with the patent office. So there is a provisional patent application that you can file. Now, that won't be examined by the patent examiner. What it will do is it will hold your place in line, in essence. So remember, I said time is of the essence. So if you need some time to kind of do some more experiments, do a little more testing, or make some improvements or whatever it is to your invention, then you can go ahead and file that provisional, and it will hold your pace in line for 12 months. If you miss that 12-month deadline and somebody else comes in after you, then you could lose your opportunity to obtain that patent. Remember, timing is so important when it comes to patent law, so you do not want to miss any deadlines. Think 12 months. 12 months is a lot of the deadlines are within that 12 months there. So just make sure that if you have that provisional, I think I froze there. But before the end of 12 months, you want to make sure that you have that non-provisional application, which is the application that will ultimately be issued into your patent. Make sure that you get that in before the end of 12 months of that provisional, and that'll save your place in line. And so if somebody files after your provisional date, then you're good to go on that. So that's another thing that you just want to keep in mind. You really want to get these timelines down. You really want to make sure that you know what you're getting into before you decide to file your patent application. Because like I said earlier, it's very technical, it's very specific, and it's very timeline driven. So you don't want to miss those important dates there. Know that you want to do your research before you file your patent. So everybody comes up with a lot of, let me not say everybody, but a lot of people come up with the same ideas. And it's probably great and it's probably wonderful, but somebody else might also have that idea, or somebody else might have already patented. Now keep in mind that there's a lot of things that have been granted for a patent that we don't know about, that they're just not using for whatever reason, they're just holding on to it. I know one particular company just files a lot of patents, they hold on to it because somebody might infringe on that patent, and they're gonna go ahead and sue them for infringement. That's a big company, they have a lot of money, they can do that. So you can go to Google Patents, you can look up what has already been patented in that space and in that area. You could possibly find that you have an improvement of what it is. If I have an improvement to the Keurig, again, a non-obvious improvement, I can get a patent for that. But if I'm trying to claim the exact same thing, you're not going to be able to get that patent. So what it is, your invention is made up of claims. So I won't go into the details of what those claims are, but basically they're sentences that describe your patent. And so what the examiner is going to do is they are going to compare each and every one of those claims, each and every one of those sentences in your patent application to previous patent either applications or patents that have been granted, and they want to make sure that there is no overlap or that it's not an obvious rendition of something that's already been granted or something that's already on file. So that's why you want to do your research. You want to look to see what's out there. You want to make sure that you are not trying to patent the same thing, because you will get a rejection. Now, you will most likely always get an initial rejection from the patent office. It could be something really big, it could be something really small. Again, be patient. It's a long process, but at the end, it's worth it. And do know, once you get on file with the patent office, you can start saying patent pending. So that's a good thing, but you cannot start maintaining those rights. You cannot file for infringement until you have been granted and issued that patent. So I know I said a lot here. I know there's so much information, but I wanted to make sure that you had those little nuggets there so that you know what you're getting into, that you know what your rights are when it comes to patent law and your inventions. Listen, there's so much creativity going on out there. There's so many creative minds. It's your work. Protect it. You want to make sure that somebody else can't come behind you and take what you have worked so hard for. If you have any questions, again, my email is below. Please email me. Let me know if there's something else you want to talk about. If there's a specific topic, a specific question that you want me to answer, I can answer it in my next video. I appreciate all of you watching, all the likes, all the comments. Thank you, and I'll see you next time. Bye, guys.